Those days when loyalty alone was enough to keep employees in the fold, sometimes for their entire careers, have long since passed. Lured by creative compensation packages, nowadays employees think nothing of jumping from company to company. And every day, as you know, your business's top talent and its most important data is at risk. The dramatic rise in employee mobility, coupled with international travel, remote computer access, and portable thumb drives, has made it more difficult than ever to safeguard confidential information. But how does your company handle any of these increasingly common occurrences? Before resigning, an employee downloads your confidential customer-related data, technical specifications, and other valuable documents into a portable thumb drive. Your competitor begins courting your best employees in an all-out attempt to raid your top talent. A new employee starts work and presents you with classified data from his or her previous employer. Or, while online, you find that your company's most sensitive data has been anonymously posted on websites and blogs. In many cases, this information, known as trade secrets, can be vital to a company's long-term success and can be one of the largest assets on your corporate financial statements. An alternative to a patent or copyright, a trade secret is legally defined as any information that generates economic value for its owner. 1, from not being generally known to industry competitors, and 2, which is subject to reasonable efforts to preserve its secrecy. As a result, trade secrets include not only formulas, such as the highly guarded recipe for making Coca-Cola, but customer information, marketing strategies, and pricing information. Fortunately, there is good news for any organization that wants to protect its assets that are known as trade secrets. A few weeks ago, Congress enacted and President Obama signed into law the Defend Trade Secrets Act of 2016, which amends the Economic Espionage Act to provide a federal civil cause of action for misappropriation of trade secrets. Until now, federal law provided only for criminal prosecution of trade secret misappropriation by prosecutors, without an effective federal remedy or a predictable outcome to protect the owners of trade secrets. As a result, prior to the new legislation, the protection of trade secrets was largely a matter of state law and was based primarily on the Uniform Trade Secrets Act.
With us is Barry J. Waters, who counsels and defends businesses as a partner in the New Haven office of Murtha Kalina LLP. Thanks for joining us this month, Barry.
It's my pleasure, Becky. I'm glad to be here.
Well, as you know, Barry, our viewers consider themselves to be the steward of their organization's assets. When it comes to intellectual property, it seems that more and more businesses are increasingly concerned with and are struggling to protect their assets these days. Why is that?
Well, the big problem is everybody's on the internet. Everybody does electronic email. Everybody is tweeting and using all kinds of ways to communicate electronically, which is fairly new. So information is out there. In today's world, business is international, and both employees and information are mobile around the world.
Well, that makes sense, Barry, but what specific threats are businesses facing?
Well, what makes the news are the international threats of espionage. You have foreign companies and frankly, foreign entities, governments. But the biggest threat is internal. Your own employees, specifically in IT and in sales. That's where you get the biggest leakage of trade secrets. So employees will leak information either intentionally because they're unhappy with a company, they've had an offer from a competitor, or biggest leakage is probably just inadvertent, that they get a phishing email and they respond to it, and this causes leakage.
Okay, I've heard about trade secrets, and I know those aren't the same as patents. Remind me, what's the basic distinction?
Very good question, Becky, and that's the kind of question we get from clients right off the top. Trade secrets are things that are secret, obviously. That's information you don't want anyone in the public to know about. So, for example, if you were in manufacturing, the machine you use to make your product in the factory, that could be a trade secret because it's not exposed to the public. But the product that you actually sell to the public can be easily reverse engineered, and you want to patent that. Same with information. If you have a website, a financial website, the information on the website obviously is not secret. Too often, though, companies do put important confidential information on their websites. You've got to be careful about that. But the kind of information you bundle that's unique to the way you do business, you don't publish that to the public. That's what you want to protect as a trade secret.
In that context, Mike just told me about the enactment of a brand new federal law, the Defend Trade Secrets Act. Why is it such a big deal that businesses can now file federal civil lawsuits for the theft of their trade secrets?
Well, I think it's frankly a question of quality. The state courts are very good, but they're generally underfunded. Federal courts are better funded, and so you can expect a high quality of justice in the federal courts. Most litigators would prefer to be in federal court. So being in federal court gives you the uniformity across the United States. The law itself isn't new. You have trade secret acts in 48 of the 50 states, and in those states that don't have the actual act, they have common law protecting trade secrets. But the case law varies from state to state. So you get uniformity, you get quality. So as a result, there's a higher level of justice, and most companies want that.
I'm curious, what does it mean in that context that a trade secret is, quote, misappropriated, end quote, by improper means?
Well, improper means, Becky, is exactly what it sounds like. It could be by theft, it could be by espionage, but frankly, most of the time today, it's an electronic means. Someone is phishing and getting into your database, or, as we talked about already, you have an employee's disgruntled and taking the information, or someone inadvertently allows the information to be taken.
Well, I want to ask you more about the new law in a few minutes, but first, let's make sure that I'm up to speed on trade secrets. For instance, when I used to go to the movies, the thieves would drive up to the company with a truck and they would have to remove an entire safe from a building. In today's films, the bad guys or gals just walk out the front door with a thumb drive in their pockets, don't they?
Well, that's true because we do business electronically today. Paper is leaving the premises, as they say. We here at Murtha Cullina try to have a paperless office. So in the financial world, of course, you're doing business electronically around the world. So the thief is going to have a thumb drive. A thief is going to have an insider who's passing the information to the outside. You know, unfortunately, there's nobody watching your IT people. It may surprise you to learn that IT people are the ones who are passing information. And the other point of vulnerability, Becky, are salespeople. As they're out there and they're always trading information and they're always looking for jobs.
Well, that makes sense, Barry. But tell me, is there a difference between protecting a company's data and information and protecting its trade secrets?
Well, data information quite possibly is a trade secret. There's personal information that the public is concerned about that you don't disclose. Financial institutions, of course, are very sensitive to that. But bundling of that personal information might create a trade secret. You know, it's not just who you are, Becky, but where you golf, what your kids' names are, what your income level is, what your preferences are, both in investing terms and personal preferences. All of that information together could constitute a trade secret.
Of course, whenever you mention trade secrets, Barry, I immediately picture an armed guard watching over the secret recipe for Coca-Cola. But a lot of our viewers are in service businesses or in financial services. Does the concept of trade secrets apply to those industries too?
Absolutely. The Coke secret is the classic trade secret. Only a few people in Coca-Cola's company would ever know that secret. Unfortunately, when you do business worldwide, when you do business with a lot of customers and you're dealing in financial information, people in the company have to have access to this information. You want to limit it to a need-to-know basis. But again, that bundling of the financial information together is something your competitor does not have, and you don't want that competitor to have that information. So, Becky, in financial services, of course, you have your own software that's converted to particular uses for particular customers. It's not off the shelf, and that's the kind of information that you develop over a period of years with technologists and with salespeople. And that's the kind of bundled information that you don't want in the hands of your competitors.
Does that mean that a trade secret is always either written down on a piece of paper or stored in a computer?
No, it isn't. Most of the time it's going to be somewhere on a computer. But if you could take it out in your head, it's a protectable trade secret. Mostly the general information, Becky, that you take out as an employee is not protectable. I learned certain things on the job. I'm entitled to take that experience somewhere else. But what I'm not entitled to take is some particular way of doing business that's unique to my current employer. I can't take that to a new employer.
Let me ask you about a hypothetical situation, Barry, where a company has very distinctive-looking delivery trucks that bring its products to its customers. I suppose if a competitor wanted to, they could just follow the company's delivery vans and see who their customers are. So is their customer list a trade secret, or is it something that's generally known?
Well, Becky, following the van itself doesn't get you to the information that's bundled and would be the trade secret. Just because a customer resides at a certain address doesn't get you in the door to make a sale. So what you really have to know is who's the manager, who's the person that you really need to speak to, who are the salespeople, what relationships do we have, and you know, the pricing information, the costing information. These particulars about the relationship is what constitutes the trade secret. But anything out there in the public, where a particular company is located, that's public information. You could never protect that.
You mentioned patents, Barry, but this is different, isn't it? I mean, you're not going to the government and to the whole world and say, here's what I've done, give me an exclusive license to use it.
Very true. Good point, Becky. Here's the issue. The information that you have that you would consider a trade secret is a trade secret because you haven't shared it. Where your delivery truck goes is out there for anyone with two eyes to see. But the information we're talking about is you're keeping it in-house, you're keeping it on a need-to-know basis, and you expect your employees to be loyal and competent and not share that information with competitors.
And let me return to the new law, Barry. On the one hand, you already told me that it provides companies with a federal civil cause of action for misappropriation of a trade secret. But on the other hand, it also contains a seizure provision. What does that mean in this context?
Well, Becky, the seizure provision has gotten a lot of press. But frankly, it's hard to imagine that it will be used very often because the law is very conservative on when a seizure remedy would be granted by a judge. And in fact, a traditional injunction, a temporary injunction, a preliminary injunction, a temporary restraining order will normally get you the kind of stoppage of the leakage that we're talking about without seizing the actual information, or if it were machinery, I suppose you could seize the machine, but you could also have an order that says you can't move that machinery. So I'm not sure that this seizure provision will be used all that often. But it is unique to the federal law. So, you know, as a practical matter, I had a case where someone stole drawings from my client, took them to a competitor, and then the competitor had these drawings used to make new equipment. And when we found out about this, we got an injunction against that equipment being sold to customers. And that stopped their operation cold. Seizing the equipment and actually taking out of the factory and putting it somewhere else wouldn't have been a better remedy. So that's why I find it hard to imagine this coming into common use, this seizure provision.
So in addition to the federal statute, each state can still adopt its own trade secret law, presumably based on the Uniform Trade Secrets Act. But I recall from other programs that we've done that when they actually get enacted, state laws aren't always that uniform, right?
Well, very good, Becky. That is the problem, because in each state legislature you have individuals who want to monkey with the particular language that's supposed to be uniform. That's the point of the Uniform Trade Secrets Act. Unfortunately, in Idaho, they may do it a little differently than they do here in Connecticut. So then you have judges who are from the various states interpreting their own law a little differently, and what you have is confusion. And what we're looking for is uniformity.
Well, you know our viewers, Barry. After all, they're your clients. They've got operations, customers, vendors, and employees on every continent. To what extent do these laws, either the new federal statute or those state acts, follow business trade secrets all around the globe?
Well, that's a good question, Becky, because Congress is obviously very mindful of international theft of trade secrets from government agencies and from private businesses in foreign lands. Unfortunately, it's still up in the air as to whether Congress intends an extraterritorial effect of this statute. And as a practical matter, if you want to recover trade secrets in, let's say, the Netherlands, you're going to have to go into court in the Netherlands. And the question is, what will the judge there do? So I do believe that we are evolving in many areas of the law to an international body of law, and I think this is one area that will evolve eventually. But as of today, you do have to depend on the courts in those jurisdictions. I went to Berlin last week for the annual meeting, and it's striking to me over the years how uniform the law is getting around the world, particularly in this area, non-compete agreements and trade secrets. So I do think that the federal law is now going to help push the envelope on the development of law internationally.
Well, in order for information to be a trade secret, companies must make reasonable efforts to maintain the secrecy. I'm curious, Barry, are there specific protection measures that must be employed?
So there is something you can do now. You can look at your confidentiality agreements, you can look at your non-compete agreements, and make sure that you require that U.S. law applies and that federal law applies, and that venue for any dispute would be in the United States. That would give you a broader effect to the statute.
But what is the threat to your company? In fact, many corporate financial executives are dismayed to learn how common the loss of trade secrets is and how few organizations, including their own, are doing anything about it. According to a recent survey, the 1,000 largest American companies lost more than $300 billion last year through the theft of proprietary information. An even more startling survey finding is that most companies have not established procedures for identifying and protecting their trade secrets. As a result, litigation has flourished as more companies are racing to protect their trade secrets. According to recent statistics, trade secret litigation doubled from 1995 to 2005, and all signs indicate that they are going to double again in the current decade. And in a major decision last year, an appellate court upheld a major trial victory by Hallmark cards and even found that Hallmark's PowerPoint presentations constituted trade secrets under the Missouri Uniform Trade Secrets Act. Specifically, the Eighth Circuit Court of Appeals affirmed a jury verdict of more than $30 million, including $10 million in punitive damages in favor of Hallmark cards. In the action by Hallmark, a private equity firm known as Monitor Clipper Partners was found to have misappropriated confidential information from Hallmark, including data from in-house PowerPoint presentations.
Over the years, we've reported on the Dodd-Frank Act and other laws, and one of their objectives is to get corporate organizations in general and financial institutions in particular to be more transparent. To some extent, doesn't that go against the notion of keeping information secret?
So, Becky, one of the things that companies may overlook as you're developing new products and new services, as you're bundling new information, you're very excited about how it's going to gain you an advantage in the marketplace, but perhaps you're not focusing on the fact that this could be trade secret material, that it is protectable, and to keep it protected. Both under the existing state statutes, under the new federal statute, you have to take steps to protect it. You have to limit access to that information on a need-to-know basis. You have to have confidentiality agreements. You can't just have people getting onto your computer system and having access to what you are going to say in retrospect was a trade secret. It's not a trade secret if you have everyone looking at it and using it.
Well, I'm sure that you've noticed the trend, haven't you, Barry, where companies are working more closely with their suppliers and customers in terms of sharing information?
Well, that's absolutely true, and the problem in terms of secrecy is you're sharing that information around the globe. You're not just sharing it here in the United States. And you need to share the information in order to do business. So you protect yourself as best you can. You have to have confidentiality agreements with your suppliers, your vendors, your customers even, anybody you do business with. And so you want to make sure you have in place some protection so if there is leakage, you have a cause of action against them.
Well, in connection with trade secrets, I've heard the phrase doctrine of inevitable disclosure. And I certainly know what each of those words means individually, but what does the phrase mean in this context?
Well, the doctrine of inevitable disclosure has been developed through case law. And to make it quite simple, it really means that it is inevitable that you will disclose my secret information if you go and take a job with my competitor. And it has been said that if you go to a competitor and if you have that kind of information that's sensitive, I know you're going to disclose it. And some courts have issued injunctions against working for a competitor simply because the person who left has the information.
So in the context of protecting your trade secrets under the new federal law, can you really enjoin an employee from going to work for a competitor?
Well, only if you have some information that there's a great possibility that your trade secret information will be disclosed. For example, you find out that someone has left the company taking out an insertable drive. You can find that out through forensic examination of the computers, or you have somebody who has a history of stealing information, or your competitor has a reputation for having hired people with stolen information. So there has to be some evidence that an actual misappropriation is going on. You can't simply assume that because your employee went to a competitor, your employee inevitably will disclose that information.
What about from the other perspective, Barry? Since our viewers' companies are currently in boarding new staff members, to what extent should a company's hiring decision or its intake processes also be influenced by that inevitable disclosure doctrine?
Well, Becky, there's a tension here because obviously our clients are in business to make money, and they want to get a jump on the competition, and sometimes, particularly from a sales point of view, that means hiring someone who has some information from a previous employment, but that's risky business. Our advice, of course, is that you do a full vetting process before you hire someone. You find out whether that employee has a non-compete agreement, has signed a confidentiality agreement, has had access to confidential information, and you get a statement from that prospective employee that he or she is not going to bring that kind of information to you. One of the big problems is a salesperson might have confidential information from a former employment and then enter this information into your local area network, and you don't even know what's happened. Now you have misappropriated that trade secret information, and you didn't even know it happened.
I heard you speak about non-compete agreements, but I also heard you mention a confidentiality agreement. Remind me, Barry, are those essentially the same thing?
No, a non-compete agreement is different, and the new federal law doesn't affect non-compete agreements. So as before, non-compete agreements will be determined enforceable or not under state law. But I think if you really want to protect your confidential information, which includes your contacts, your pricing information, and that sort of thing, you want to have a non-compete agreement. That is, your employee can't work for a competitor in a lot of situations. In other situations, you might not require a non-compete. You're okay with your former employee working for a competitor as long as they don't solicit your customers or clients. And in all situations, to bolster the enforceability of the trade secret protection, you want a confidentiality agreement. So I think the broad focus here is for companies to consider whether they have non-competes, whether they have non-solicitations, what they're doing to protect their trade secret information with confidentiality agreements and limiting access on a need-to-know basis. And it's looking at the big picture of all of those things that will help protect your competitive advantage. After all, that's what you want to do.
Well, the company has a general counsel, it's got an IT staff and an HR staff. Is it really necessary for financial executives to be concerned about protecting trade secrets?
Absolutely. And in fact, I'm hoping that in your company, that the viewers listening here have in-house counsel, have a very good IT staff, have a very good compliance staff, and they're working together to stop the espionage and to stop the leakage of trade secret. And they should meet regularly and review whatever procedures are in place, whatever agreements employees are required to sign.
As financial executives, our viewers know the value of taking inventory and of conducting an audit. To what extent are those concepts applicable in the area of trade secrets?
Absolutely necessary. What we see oftentimes is non-compete agreements are taken off the shelf at some time in the past. Maybe the whole management team has turned over and you still have those agreements. Maybe the company has gone into new territories and the non-compete agreement doesn't consider that. Same with the confidentiality agreement. The information that you consider to be a trade secret changes over time. In today's world, it changes very, very rapidly, particularly in the financial industry. So you really should have a regular review of the documents that you sign, review with IT about the protections that are in place to make sure your information is not leaking. You should have a thoroughgoing interview process when you hire people and a thoroughgoing exit interview process to make sure that people leaving the company are not taking information with them.
Well, our viewers certainly know how to inventory their tangible assets, but do they necessarily know how to conduct an audit of their intangible or intellectual property?
Well, I don't think they necessarily do, Becky. And obviously, there are different size companies and different levels of sophistication. Some have in-house counsel, others don't. But even where you have in-house counsel and you have a good IT department, it's very important to get outside help, just as you would with an auditor. So you want someone who's experienced in trade secret law, who's seen how these cases go, who knows the soft underbelly, if you will, and you need an IT forensic person who's accustomed to defending these kinds of cases or prosecuting them on behalf of the company and knows how to handle the information. One of the problems is you need evidence that's admissible in court if you have one of these trade secret leakage issues, and you can't use your in-house IT people for that. So yes, we very much do encourage companies, financial companies in particular, to use outside resources to work with the in-house people, not to work independently of the in-house people.
The law continues to evolve in this area, but so does the technology. Do companies need to refine their trade secret policies each time the law changes, as it just did, or each time the technology changes, as it always does?
Well, the technology is going to be ahead of the law, that's for sure, Becky. And so you definitely have to review your policies. You have to review how you keep secrets secret. If you have a new development of any kind, new software, you want to make sure that people are aware of it only on a need-to-know basis, and that the receptionist, for example, is not given access to information that she doesn't need to have. So absolutely, the law will evolve, but the technology is going to evolve a lot faster, and the law tries to catch up with that.
Well, you've certainly covered a lot of ground for us this month, Barry. If our viewers could take one thought away from this discussion, what would you like that to be?
Well, I think you have to go back and look at your confidentiality agreements. Make sure you have good ones. One aspect of this new federal law is the whistleblower section. And under the whistleblower section, your employee can actually take trade secret information to the government or to a lawyer, any lawyer, if it's in the context of blowing the whistle. And if that were to happen, that employee cannot trade the information publicly, obviously, but you're going to be concerned about it being in the hands of even the government or an independent lawyer. The statute provides that if you bring a trade secret action, you can recover your damages. You have the opportunity under certain circumstances to recover double damages and attorney's fees. If you don't put a paragraph in your confidentiality agreement that tells the employee of this so-called safe harbor for whistleblowing, that we're not going to sue you because you took information to the government in a whistleblower context, then you won't be able to avail yourself of the opportunity for double damages and attorney's fees in any case, not just the case that we're talking about here in the whistleblower situation. So the most important thing, I think, right now is to go back and review your confidentiality agreement, insert the paragraph that now will give you a better opportunity for damages under the new statute.
Mirtha Kalina's Barry Waters, thanks for bringing us up to date.
It was my pleasure, Becky. Glad to meet you.